Hi, my name is Goldman, and I'm an attorney with Goldman and Associates. Today I'd like to talk to you about probate. A lot of people want to find out what is probate and what do we got to do to probate something? What does it mean to probate something? Well, the probate court essentially was established in order to assist people with certain kinds of things. It is involved in guardianships, conservatorships. Sometimes the probate court has issues regarding minor children. In most cases, the probate court is used to establish and resolve estates. A lot of people don't want their estate tied up in probate. Half of them don't even know what those words mean, but they know that the courts are slow, the probate courts are particularly slow, and they feel that if they have an estate and it ends up in probate court, that's going to take many, many years to resolve. It's possible that they're right. In some cases, it does take a long time to resolve, particularly a disputed estate. But that's really a subject matter for a different discussion. Right now, I want to talk to you a little bit about how the process begins. If somebody dies and they have a will, and the will has to be probated so that the party's wishes under the will can be fulfilled and property dispersed to heirs, what has to happen is you got to initiate proceedings. So you got to file what is required to an appropriate petition to commence proceedings, and then the court will open up the probate file and the court will appoint a personal representative. The personal representative is essentially the point man that the court's going to look to be in charge of this. Because the last thing the court wants to do is deal with a bunch of your heirs, okay? So it doesn't want to talk to your heirs. It doesn't want to talk to anybody's heirs. We'll talk to one person, or sometimes two if they're co-PRs. But sometimes there's one PR, one personal representative, and that's the point person for the court. Now, the will often will name a personal representative. That makes it real easy. But if the will doesn't name a PR, or there is no will, the person dies without the benefit of the will, then somebody, it could be an heir, it could be a friend, somebody would have to petition the court to administer the estate and become the personal representative of the estate, and the court will have a hearing to determine who that should be. And once the court makes that determination, the court furnishes that person with what is called letters of authority. Letters of authority is the thing that allows you to act on behalf of the estate. Because remember one thing, when a person is alive and he goes to the bank, if he's got an account in his name, he's the only one who can act on his behalf to deal with that account. Take out money, put money in, do whatever. When that person dies, there's nobody who can act on behalf of that dead person unless the court creates an artificial person to be able to do that. The court creates an estate and then creates a personal representative who administers that estate, and that's the person who can now go into the accounts, pay bills, take out and garner all the assets, and then if there is a will, follow the terms of the will to distribute those assets in accordance with those terms. Obviously, this is very complex. It's very case specific. If you have any questions about it, reach out to us, and of course, we'll be glad to help you out.